Morning, Jesse.
What's going on? How are you?
Doing well. How you doing?
Doing well, man. We get cracking here in a minute.
Cool.
Morning, Jess. Morning, everybody.
What's happening? How are you?
Good. How are you?
Good. You guys have questions before we get started?
Nope.
Okay. All right, we'll go ahead and get started. We'll probably be low on numbers for the next little while, just because we've got a regional ignite going on. We've got Bold, I think, is going on. We've got family reunion that's going to be going on. During family reunion, we aren't going to have class. I got to look at the dates and figure that stuff out. So we'll keep you guys updated on all that stuff. But last week we did competitive writing a competitive offer in a multiple offer situation stuff. So kind of back to the beginning of our typical rotation, unless someone else has something pressing that they need. I figured we'd start with contract or exclusive right to buy, and really the precursor to the exclusive right to buy. Good idea to review the brokerage disclosure to buyer. Brokerage disclosure to buyer is one of those things that is just so neglected. So many people just don't even know it exists. They don't know what it's for. And so really what it's for is the real estate commission says that we have to disclose our brokerage relationship in writing at the first reasonable opportunity, and really prior to soliciting any confidential information, any motivations, any of that type of stuff. And so what the brokerage disclosure to buyer does is, unless you sign an exclusive right to buy at the very first time you meet someone, right, then you probably have not met your legal obligation to disclose your brokerage relationship in writing. Well, not everybody wants to sign an exclusive agreement where they have to work exclusively with you at that very first time that you meet with them, right? And so, maybe for your friends, right, or your family, or, people in your sphere, right, maybe they're willing to sign something right at the beginning. But let's just say a member of the general public, right? You've never met these people. It's a sign call, right, or a floor call or whatever. You don't know who they are. Well, what are the chances that the very first time they come in to talk to you, that they say, "Hey, Kevin, like, you're the man. I love the beard, so I'm signing a contract with you," right? Like, most people just don't want to lock themselves down to something until they've tested that relationship out a little bit. And so, I always say they don't want to get married to you on the first date, right? And so if that's the case, if they're not going to sign that exclusive right to buy, okay, then we still have to disclose our written relationship, our brokerage relationship with them. And the real estate commission, right, the default is, unless you sign an exclusive right to buy with me and we check that little box that says I'll be your agent at the top, by default, what is my relationship with you? Anybody? It's not a trick question.
Customer.
So customer is an option, right? And customer is an option, particularly if you are an agent on behalf of the seller, right? And Grady chimed in and he said transaction broker, right? So by default, I am a transaction broker, unless, of course, I check the box in the brokerage disclosure to buyer saying customer, right? But yeah, by default, I am a transaction broker for you. And transaction brokerage is a brokerage relationship, whereas customer is not, right? And so the brokerage disclosure to buyer is effectively saying, "Hey, buyer, that's fine. We don't have to get married today, right? We don't have to sign an exclusive relationship where you are agreeing to work exclusively with me But I just have to let you know that until you do, I can't be a buyer's agent for you. I can only be a transaction broker by default. And the duties that I have as a transaction broker are limited. I cannot perform those duties of a buyer's agent. Okay. So you guys know what the duties of a buyer's agent are? In addition to all of the duties of a transaction broker, there's 3 of them. Does anybody know what they are? So I'll pull up the contract here and show you where those are at. So if in the exclusive right to buy, and we'll come back to the broker disclosure to buyer, but in section 6, let me share it here. So in section 6, these are the duties of a buyer's agent, right? And so promoting the interest of the buyer with the utmost good faith, loyalty, and fidelity. Well, you legally cannot do that if you are acting strictly as a transaction broker for the buyer. Okay. Seeking a price and terms that are acceptable to the buyer. You cannot do that if you're acting solely as a transaction broker. Counseling the buyers to any material benefits or risks of a transaction that are actually known by broker. Again, can't do that unless you are specifically acting as a buyer's agent. Okay. So you do still have all of these duties in section 5, which we'll I don't even know if we'll get that far today, but we'll look first at the broker disclosure to buyer. Okay. And we'll review that so that you guys can at least be versed and know, hey, this is what this means. This is how I present this form. And it is important because the reason that I pushed this form so hard is that we had an agent in the Loveland office who she received a real estate commission complaint. And that complaint stemmed from the fact that she was showing a property to some clients. And I'll stop the share real quick. She was showing a property to these clients, and these people had kids. And the kids were like just crazy, rambunctious kids, right? And the pictures of the house showed that there were these like cabinets or curios, that were full of all these intricate, fragile, antiques and stuff like that. And so the broker knew going in, hey, I don't really want the kids to go inside the house, right? And so what she did was she opened up the lockbox. She, takes the key out, opens up the door, lets one of the clients in while the broker stayed outside with the kids. Well, that in and of itself is a little bit of a problem, right? Who's supervising the people inside the house? The better way to potentially handle that would be, broker goes in with Mrs. Seller or Mrs. Buyer first, right? While Mr. Buyer or whoever hangs outside with the kids. Okay. And then once Mrs. Buyer's done inside, right, she can swap with Mr. Buyer, and then broker goes inside with Mr. Buyer. So that was the first part of the problem. And then the second part of the problem was when they were done, these buyers, right, everybody comes out of the property. Broker was still hanging out in the front yard with the kids. And the key was in the door, right? She had left the key in the door. And so anyway, they get to talking. These buyers really liked this house. And so they talked in the front yard for like 15 minutes about the logistics as far as putting in an offer on this place and all this other stuff, right? And so they were excited about the house. And then lo and behold, they just got so caught up in talking logistics and talking details about the offer and all this other stuff that the broker just forgot that the house was still open and that the key was in the door. And then they take off and leave. Okay. So not only is the front door open, the key is still in the door. And, now they've driven off. Well, guess what? The sellers had the, Ring doorbell or whatever, that was recording everything. And sellers are on vacation. They had just left like an hour ago. Okay. So they weren't that far away, but they were driving, to wherever their destination was. And they had left an hour before this showing started to go on vacation. And so, now they turn around and come back home, right, and have to lock their house up And yes, there's better ways that they could have done that. They could have called their agent, said, hey, who's the idiot that just showed our house? Tell them to go back and lock the door, right? But they felt a need to, come back home, drive an hour back home, lock up their front door, and now they've lost 2 hours of vacation time, and they're, yelling and screaming at their broker, right? So they file a real estate commission complaint, and the commission, when a complaint is lodged, they have to investigate it. Doesn't mean that it has to turn into, punishment or anything, but they have to investigate. So they start their investigation, and lo and behold, they, basically just a slap on the wrist, and they say, hey, yeah, you forgot to lock the door. I don't think it was intentional, anything else. And they were like, no foul on that, right? Just don't do it again. But we can pop you $2,500 because all your file that you turned over to us, you have no exclusive right to buy with these people, and you have no broker disclosure to buyer disclosing your brokerage relationship with them, right? And so now she's violated a real estate commission rule that has nothing to do with what the complaint was initially about, okay? And so they could have, unfortunately, we were able to kind of negotiate with the investigator and get him to drop, any form of punishment, but he could have fined her up to $2,500 just because she didn't have a brokerage disclosure to buyer in her file, and she hadn't signed an exclusive right to buy. And because they had gone out and seen homes in person, the real estate commission said, you've had your reasonable opportunity to get at least one or the other signed, right? And so that's why this is so important, is that it is something the real estate commission will fine people for, if you don't have proper paperwork in your file. Okay, so it is important. So let's go and look at what the broker disclosure to buyer actually says. So the very obviously up at the top, you've got your branding or whatever, and then just the standard, this is, pre-printed portions of this form have been approved by the real estate commission, tells you the version of the form. Okay, and then it tells them that different brokerage relationships are available, which include seller agency, which obviously if you're giving this to a buyer, right, that's not going to apply. Buyer's agency, which could be a potential option, or transaction brokerage, right? Those are the brokerage relationships. Now, there's that other relationship that's not a brokerage relationship, right? And that's a customer. Okay. And so the first thing that it does is it defines what each of those are. We're not going to look at seller's agent because that's not going to apply to a broker in a broker disclosure to buyer, right? But a buyer's agent is someone who works solely on behalf of the buyer to promote the best interests of the buyer with the utmost good faith, loyalty, and fidelity. So like what we just talked about, those duties are. They negotiate on behalf of and act as an advocate for the buyer, right? They have to disclose to potential sellers any adverse material facts that they actually know about, including buyer's financials, right? And if it's a residential property, they have to disclose whether the buyer intends to occupy the property or not, okay? But a separate agreement, written agreement is required, which sets forth those duties in order for you to be a buyer's agent, okay? Now, the other brokerage relationship option for a buyer would be transaction broker. Now, a transaction broker assists the buyers or seller or both throughout the transaction by performing any terms, whether they're written or oral. They perform the terms of the agreement. They keep the parties informed. They present all offers to and from the other parties. Okay, they help to close the transaction without being an agent or an advocate for any of the parties. Okay, they must use reasonable skill and care, not scare, reasonable skill and care in the performance of any oral written agreements. They have to, make the same disclosures as agents regarding any adverse material facts that they actually know about, and including the buyer's financial ability to perform, right? And so one of the tactics that we talked about last week in the multiple offer class was the possibility of waiving your conditional sale, even if you have to sell the property, right? And if a buyer has to sell their current home in order to purchase a new property, right, you can waive the conditional sale contingency, right? But you still have to disclose to the other side, hey, I can't perform the terms of this contract unless I do sell. I'm just saying I'm not going to have a contingency. And therefore, if my conditional sale doesn't work out, I'm putting my earnest money at risk. Okay. So that would be an example of the buyer's financial ability to perform that may have to be disclosed. Okay. If it's a residential property where the buyer intends to occupy the property, would need to be disclosed as well. Okay. And what it says is no written agreement is required for you to be a transaction broker. That is because transaction broker by nature is the default brokerage relationship that you have with the general public. Now, what that means, if there is no written agreement required, is that they are not obligated to work exclusively with you. Hence, there is no exclusive right to buy. Okay. The other thing is there's no promise of paying you any type of commission or success fee if you are acting as a transaction broker. Okay. So being a transaction broker without some kind of written agreement, right, it offers zero protection for you as the broker, but it does obligate you to perform those Section 5 duties of a transaction broker that we'll cover. Okay. And then customer is a party to a real estate transaction where the broker has no brokerage relationship because that party is not engaged or employed the broker either as an agent or a transaction broker, right? And really the only time that you can do this is if you are representing the seller as a seller's agent, right? And you pick up an unrepresented buyer and seller says, no, you can't switch into a transaction brokerage capacity. And buyer says, I don't care, I still want the property and I want to work through you, right? So I'm going to remain a seller's agent and treat the buyer as a customer. The other potential option is just the other way around, right? Where you are working with a buyer as a buyer's agent and for sale by owner, right? Who doesn't have a brokerage relationship with anybody, says, okay, your buyer wants to purchase my property. That's fine. I'm not going to have you as the buyer's agent represent me. I'm not asking you to switch into transaction brokerage, right? So you can treat me as a customer to the transaction, and I understand you're going to treat the buyer as a buyer's agent. Okay. What you can never do is you can never treat both parties as a customer, right? So if somebody calls you and says, hey, Charlton, I want you to put together some paperwork. I'm going to sell the house that, let's say it's a mom, right? The mom wants to sell the house to her son. Okay. Well, they call you up and they say, hey, we don't want you to list a property. We don't want it to go on the open market. I'm selling the property to my son. I want you to just do paperwork. Well, you can't just do paperwork. You have to have a brokerage relationship with one or both parties. Treating both parties as customers means you are practicing law, and we don't have the ability to practice law other than a limited right to practice law, which falls under the umbrella of brokerage relationships, right? So you could still put that transaction together, right? If the mom wants to sell the property to her son, and probably the most reasonable setup for that is to be a transaction broker for both parties, right? And there is no standard commission, right? And so you could theoretically put that deal together for $500 if you wanted to. Now, your office policy might say otherwise, but from a real estate commission perspective, that they don't care whether you charge $1 or $1,000 or $100,000, right? It doesn't matter. What matters to them is the brokerage relationship and understanding, which lane am I in? Am I a buyer's agent? Am I a transaction broker? Am I a seller's agent treating the buyer as a customer, vice versa, right? So you need to understand that there is no standard commission, okay? So any questions on that piece, that definitions of the working relationships, potential options, what do you do in certain situations? Because there's some weird stuff that comes up from time to time, right? And I guess I'll just throw you guys a curveball, right? The real estate commission says that if we are representing ourselves or our family members or close friends or someone with whom we have a really close relationship where being a neutral third party would be difficult, right? They say we must act as a buyer's agent or a seller's agent, right? For the whichever party we have that relationship with. Well, what do you do when it's your mom that wants to sell the property to your brother? You have a familial relationship with both parties, right? So can you be a buyer's agent for the buyer and a seller's agent for the seller? You can't do that. So what do? You treat your mom as a seller's agent and your brother as a customer? Like, yeah, Kevin, yeah. He's like, yeah, I don't like my brother, so pound sand. Right? I mean, that probably doesn't work. Treating your brother as a buyer's agent and your mom as a customer, that probably doesn't work, right? Treating both of them as a transaction broker, well, the real estate commission may not like that, but that's the legal option that allows you to work within the framework, right? And probably doesn't, first of all, that the real estate commission saying that is a real estate commission position statement, which is different than a real estate commission rule. A rule is something where if you violate it, you can get fined, they could suspend, revoke your license, right? They can take action against you. Whereas a commission position statement is just offered as a directive to try to help keep you in line with rules and laws and everything else, right? But the law says you could theoretically be a transaction broker for both, right? As long as you actually stay in that lane. And as long as you don't actually put yourself in that advocacy role for one party over the other, okay? Does that make sense to everybody? So there's some weird stuff that does happen from time to time, and it's like, what should I do here? If you guys have questions on any of that stuff, just let me know, okay? So after defining the different brokerage relationships as well as customer, which is not a brokerage relationship, right? Then it says, okay, well, what is the relationship between the broker and the buyer? Broker and buyer referenced below have not entered into a buyer's agency agreement, so I can't be a buyer's agent for you. Therefore, the working relationship specified below is for a specific property. So you could either write in, 123 Main Street if it's for a specific property. And where you might do this is if you're sitting at your open house, right? And you've got 123 Main Street listed, and you should have a stack of these for when buyers come in, and you don't need to like slam this in their face at the front door and say, hey, I got to give this to you before you come in. No, that's not what this form is for. People are going to go and they're going to look at the house, and they may ask some general questions and whatever. That's all fine and good. No need to give them one of these. But if they start talking about their motivations, right? Now you need to disclose, hey, unrepresented buyer, just so you know, I have a brokerage relationship with the seller, and what you say can be used against you, right? And so you need to stop that discussion, and that's when you would present this, right? And it's not just asking any questions, right? If they say, hey, Melissa, what's the square footage of the home? Like, okay, you can give them the square feet. You don't, that's public knowledge, right? You don't need to give this to them. They start talking about like, oh, well, we'd have to sell in order to buy, and, we have X number months left on our lease, or hey, we've talked to a lender and we still need some work as far as our credit goes. Like, you're starting to get into confidential information and motives, right? And so that's when you would stop that conversation and say, okay, buyer, I needed to give this to you because of my relationship with the seller, right? And so then you could have this pre-filled out that, hey, this is for this specific property known as 123 Main Street, right? Now, you may also, have these ready and prepared for, someone who you don't know, who you are meeting for the first time, right? They got your name off of your website or whatever, and they say, hey, we're looking to buy a property. You say, great, come on into the office. Let's talk about what you're looking for. Okay. Well, they may not be ready to sign an exclusive right to buy with you at that first meeting. And so rather than reference a specific property because you don't know what they're going to want, right? You could just put any real property in the state of Colorado, or, any property in whatever county or city or whatever you want to do. I like to leave it pretty broad though, because I don't know exactly where they're going to be looking, what they're looking for. So I just put any real property in the state of Colorado. Okay. And buyer understands that buyer is not liable for broker's acts or omissions if they haven't been approved, directed, or ratified by the buyer. Okay. So bottom line is just don't do any of those things unless the buyer has directed you to do so. Okay. And then we get to the actual relation, or sorry, first we talk about the brokerage firm. All of us are part of the multiple person firm, right? And so it just says the broker reference below, which would be you, is designated by the brokerage firm to serve as the broker. If there's more than one individual that's designated, then references and any documents to broker will include all of those people, including any substitute or additional brokers. And just so you guys know, substitute or additional brokers, that's like if you leave the company while a property is under contract, then we have to, that will close out under Keller Williams, and we have to substitute somebody to take over that file. Now you're still going to be involved in it and see it through to the closing table, but we have to have somebody, we have to have the authority to substitute somebody for that. If you were to go into the hospital, right, and you couldn't be reached, we need somebody who can be substituted for you. If you've just disappeared, you're on vacation, nobody can get a hold of you, we have to have the right to substitute, or add an additional broker to the deal. Okay. The brokerage relationship exists only with the broker and doesn't extend to me as the employing broker or whoever your employing broker is at your office, right? It doesn't extend to the brokerage firm or any other brokers unless, of course, we actually designate one of those substitute or additional brokers. Okay. We're not going to talk about one person firm because that doesn't apply to anybody on this call. And then we get to the actual, okay, what is that relationship going to be? Okay, well, if you're talking about somebody who is a guest at an open house, right? It may be just that they're going to be a customer, right? Because you're the seller's agent and the buyer is just going to be a customer due to your agency relationship with the seller. Because I can't be a seller's agent and a transaction broker for the buyer. I can't be a seller's agent and a buyer's agent for the buyer. My only option if I'm a seller's agent is treat them as a customer or switch into transaction brokerage for both, right? So if I'm a seller's agent and I can't switch, then this might be my only option is, hey, unrepresented buyer, we'd love to put this deal together with you. Just so you know, I am an agent for the seller and therefore I'll be treating you as a customer in this transaction, right? As the seller's agent, I intend to perform any of the following lists, any of the following tasks, show you this property, right? Prepare and convey offers if they happen to be interested, right? It just depends, okay? Initially, it's probably just going to be show the property at the open house, okay? If they end up liking it, right, then maybe it's going to be prepare and convey offers as well, okay? And then it specifically says that broker is not the agent of the buyer, okay? And you're also not the transaction broker for the buyer unless that changes later, okay? The next option is if I'm the seller's agent and the buyer is a customer, right? But if I'm not the seller's agent, then I will treat you as a transaction broker assisting in the transaction, okay? So if they happen to come into an open house, right, and I happen to be a seller's agent, we could also check this box that says, okay, because I'm a seller's agent for this property, right, then I can only treat you as a customer for this transaction. However, I'd love the opportunity to work with you on finding you something else. And by default, unless you sign an exclusive right to buy, I can't be an agent for you either. So by default, I'll be a transaction broker for you for anything else, right? But again, keep in mind, this is not an exclusive agreement. So they don't have to work exclusively with you. There's no promise as far as getting paid any commissions or success fees, right? But what it does is it says, okay, broker, you now have all of those duties in section 5 as a transaction broker for this person if it's for a property other than the one that you have listed where you're working with the seller as a seller's agent. Okay. And then the last option is transaction brokerage. And so this would be more for like somebody's coming to meet you in the office who you've never met with before, you don't know, right? And you're not specifically related to one particular property that you're listing, right? This is just, hey, let's go look at houses and see if we can find something for you, right? You're saying, by default, I'm going to be a transaction broker in assisting you in the transaction. I am not your agent because we haven't signed that exclusive right to buy. Okay. So there's no checkbox here for you to treat someone as an agent. Okay. Keep that in mind. There's no option in a brokerage disclosure to buyer for you to represent someone as an agent. This form is really used for, like I said, that first meeting, that first reasonable opportunity, and prior to soliciting any info, confidential info, motives, that type of stuff. If they're not ready to get married to you on the first date, right? That is what this form is for. And you're just saying, okay, I can't be a buyer's agent for you. By default, I'm a transaction broker. Or if I'm representing the seller as a seller's agent, I'll treat you as a customer, right? So does that make sense to everybody why there's no agency option in this form? Does anybody have any questions about that piece or how to use this?
Just a quick question. Maybe you said this, I had to hop off real quick, so sorry if it's repeated. But if you have the broker's disclosure and they signed it, and let's say they said, okay, you're a transaction broker for now, then if you do an exclusive right to buy later and you're their agent, that automatically trump the broker's disclosure?
Correct. Yep. Now you need to still have both of those in your file, right? Because again, what happens if that complaint comes in later and they're investigating and they're like, whoa, you showed these people these property and that was your first reasonable opportunity to get it signed. Did you actually have a brokerage disclosure to buy or not? So you need to have it as part of your file that yes, your brokerage relationship will, trump whatever is in the brokerage disclosure to buyer. Okay.
Thanks.
Good question. Other questions?
If you get the ERB up front, you don't need this. Is that correct?
100% correct. Yep. So, yep. If you sign that exclusive right to buy, there is no need to have have a brokerage disclosure to buyer, because the exclusive right to buy discloses everything that's in that brokerage disclosure to buyer, right? And it also sets you apart as either buyer's agent or transaction broker. Okay. And there's no option for customer in that exclusive right to buy. Okay.
So Jesse, if you go that route right away, the exclusive right to buy, do you have to put in the comments to let Abby know that? You just
no
exclusive. Okay.
No, I mean, here's the thing with compliance, right? Is there's no way for compliance to know when you first met with these people, right? Now, Abby's not dumb, and she knows when she sees an exclusive right to buy that's signed on the same day as your offer, right? You probably need a broker disclosure to buyer. However, she's not going to be kicking that back for two reasons. One, it is theoretically possible for you to meet with someone and, the same day you fill out an exclusive right to buy and you write the contract on the same day that you meet with them for the very first time. And you haven't solicited any confidential information prior to actually writing that offer. It is theoretically possible. It is not probable, but it is theoretically possible, right? The other thing is, what we really shouldn't be doing is going back and backdating and doctoring forms to make it look like we complied with real estate commission rules. If you didn't do it, you didn't do it, and that's on you. And if you go back and backdate a form or doctor a form, then that's another rule violation, and you're just going to get popped twice. So it's not worth doing. So from a compliance perspective, there's really nothing that compliance can do other than we have it as one of our options on a checklist so that I either need it because I didn't do an exclusive right to buy up front, or I don't need it because I did an exclusive right to buy up front. Okay. That makes sense?
Mm-hmm.
Anybody else? Okay. So there's the little disclaimer: buyer consents to the broker's disclosure buyer's confidential information to the supervising broker for the purposes of proper supervision, right? So even though that brokerage relationship doesn't necessarily extend to me or whoever your employing broker happens to be, right? They do consent to disclosure of their confidential information, because as an employing broker, I have a responsibility to supervise at either a high level or a reasonable level, depending on your experience, a requirement for me to supervise at some level all of the brokers at my office, right? Provided that the supervising broker designee can't further disclose that information without the consent of the buyer or use that information to the detriment of the buyer. And so where this kind of gets a little bit weird is what happens if Jerry is representing a buyer and I happen to be representing a seller? Well, in that case, I would have to designate someone else to be the supervising broker for that particular transaction. And that confidential information shouldn't really be shared with me. And what I will tell you is, at least for me, I can't speak for other employing brokers or managing brokers, but there have been cases where confidential information has been shared with me because the agent on the other side of the deal, who happened to be at my same office, maybe didn't know that. And that being said, I still can't disclose that to the seller. I can't use that to the detriment of the buyer. Okay, so that gets a little bit weird, but I still have obligations on my side. Okay. Disclosure of settlement service costs. So this is in most of our contracts, right? Buyer is aware that there's different costs and levels of services provided by various third parties like attorneys, lenders, inspectors, title companies, whatever. Okay. And then in bold caps, right, it says this is not a contract. It's just my disclosure of my working relationship with you as a member of the public. Okay. And so what do you do when, you know, you're at the open house and you're like, buyer starts talking about their confidential information and, you know, you're like, hey, I got to stop you real quick, just so you know, I'm the seller's agent. And so I have to provide this with you. You're starting to talk about motives and whatnot. Just so you know, I have an obligation to represent the best interest of the seller, right? I'm only going to be treating you as a customer in this transaction. And this is just your acknowledgement that you understand that, right? And they go, no, I don't want to sign that. What do you do?
You put refuse to sign and you put it in your file.
Yeah, refuse to sign and then put the date in there so that you've
Right,
got, you know, the date. And then you know, sign the form and you can initial right there next to it and ask them if they'll at least initial it. And maybe they won't even initial it, but hopefully the way that you get around that is just to do it right up front, right? And so what I'll do if I'm doing an open house, and don't laugh, yes, I still do them from time to time, just not very often. Okay. But if I'm doing them, I will actually print these out and then I will either highlight or I will underline this part right here that says, this is not a contract. The other thing that I'll do is I'll underline this part that says broker is not the agent of the buyer for whichever box I'm going to be checking, right? My purpose is just to show the house and potentially prepare and convey offers. Okay. So usually if you prep them for that, hey, just so you know, I'm not your agent. This is not a contract. It doesn't obligate you to work exclusively with me. Doesn't obligate you to pay any commissions to me, right? In most cases, they go, oh yeah, that's okay. I understand that you're working on behalf of the seller. And then they'll just sign. Okay. If it's a residential transaction, the following applies. Megan's Law. If you guys don't know what Megan's Law is, just, you know, if you're concerned about the presence of a registered sex offender, then buyer, you need to go contact local law enforcement or whatever other resource would make you feel comfortable, because I don't have a duty to disclose that to you and you're not going to be able to sue me for it. Okay. And then just buyer acknowledges receipt of this document on whatever date. Okay. And then there's the broker's acknowledgement on whatever date I provided, whoever the buyers are, with this document via hard copy in person, electronic copy, whatever, you know, method you put in there. And I retained a copy for my records. The other thing that you have to do is anytime someone signs a document, you also have to give them a copy of whatever they sign. So really, theoretically, you either need to take the copy that they sign and send them an email with it, right? Or have them sign 2 copies and send them on their way with one, and retain one for your own copies or for your own file. Okay.
Can you take a picture of it and send it to them
via text or whatever. Yep.
Okay.
Yeah. Okay. As long as they've got some form of the copy of the document, that's fine. Okay. So that's the end of that document. Pretty easy. Do you guys have any questions on that particular piece, that form? Nothing? Not that.
I do have a question, Jesse.
Okay.
Jesse, this is Jeffrey. Yeah. Is there, now you said typically you're just going to want to check the box, not to prepare contracts, but just to show the property.
Correct.
Is there any consideration that should be made to just check all those boxes initially?
Yeah, so potentially you can, right? And a lot of times it's just going to be a matter of filling out these people, right? As they start walking through the house, you might start picking up on like, oh yeah, this is perfect for us. Like, we definitely, like, we're ready to go, right? Like, let's write an offer on this thing. Well, okay, then check the box, right? If they just happen to be, starting out their search and, this is the first house we've come into, whatever, right? Like, you probably aren't going to be checking that box up front. It certainly doesn't hurt to just check both either, though. But I think it just depends on your reading as far as where they stand or what's the likelihood that you're actually going to be writing an offer.
Okay.
That makes sense.
Are we going to discuss the for sale by owner disclosure also? I'm
So,
kind of curious about where
yep.
those boxes are checked in that one as well.
Yep. So after the exclusive right to buy, which just so you guys know, the exclusive right to buy, we go pretty deep in that form. And that will take a few class periods to get through. But after the exclusive right to buy is when we'll look at the brokerage disclosure to sell or FSBO. And we can do that. Now, that being said, if you're up against, a deal where you got to go put an offer in on a FSBO, don't wait until, a month from today when we get to that form. Just call me and we'll review that one-on-one.
Okay.
Okay.
Yeah, I don't have anything going on there yet, so.
Okay.
But I will if I do.
Yep.
I'll let you know.
Feel free to reach out. Any other questions on this form? Okay. Let's look at the exclusive right to buy. So again, same little disclosure at the top. This one also says this is a binding contract, right? So, different than the broker disclosure to buyer, which is not a contract. This is in fact a contract. It has important legal and tax consequences. They need to talk to an attorney or a CPA or whatever, right? There's also a disclosure that compensation charged by brokerage firms is not set by law. The brokerage firm may have the right, or they do have the right to set whatever they see it as, limits, whether those are caps or, on the low end or whatever. Okay. Brokerage firm does have the right to establish, minimum or maximum compensations that are otherwise not set by law. And so the important piece there is no standard commission, right? You may be used to seeing one particular number in your market area. That doesn't mean that it's set by law. Okay. And then same thing as in the other one, different brokerage relationships are available, which include buyer agency, seller agency, or transaction brokerage. And then we get to the part where we actually have to check the box. Of course, that seller agency box is not here because this is an exclusive right to buy. So our only brokerage relationships, again, customer is not a brokerage relationship. So our only brokerage relationship options are buyer agency or transaction brokerage. Now, there are some brokerage firms out there and their policy is to only represent their clients as transaction brokers, whether they have the other party on the other side of the transaction or not. And so, a lot of people call this an exclusive agency agreement. It is not an exclusive agency agreement. It may become an exclusive agency agreement if you check that box, but it's truly just an exclusive right to buy that could be exclusive agency or exclusive transaction brokerage. Okay. So check whichever box you feel is appropriate. At KW, we say you can be whichever one. I am an advocate for agency, particularly because when you go and you talk to someone and you say, hey, what is it that you're looking for in a real estate broker to represent you, right? What typically do they spout off or is important to them?
They want
They
you to
want you to-
represent them.
Yep.
Yeah, right. Like you could basically just go down here, skip all of section 5 and read section 6 and they go, this is what I want, right? That's what they want, is they want someone who's going to be an advocate for them. They want someone who's going to promote their best interest. They want someone who's going to treat them with good faith, loyalty, and fidelity, who's going to seek price in terms that are acceptable to them and counsel them as to any risks or benefits of the transaction, right? What they don't really ever say is any of this stuff, because this is all just assumed, right? So, you know, particularly if you know that you are competing against another broker, and if you know who that broker is and what firm they're at, you might know that they have a policy of only representing somebody as a transaction broker, okay? And the important thing to remember is if I am a transaction broker, I cannot do those things in section 6. And the real estate commission is actually coming down hard on people who are not staying in their lane, right? So if I'm a buyer's agent, I can't be neutral. And if I'm a transaction broker, I can't be an advocate. Okay. And there's some misconceptions there. A lot of people think, well, if I'm a transaction broker, I can't advise my client. And that is not correct. And we'll look at that when we get to section 5, but that is incorrect. You have to advise your client regarding the transaction. Okay. So pick whichever one you're going to be. We'll talk more about these when we get to section 5 and 6, right? Put whatever the date is, the date that you're writing the contract. Doesn't necessarily have to be the start date of, you know, your brokerage relationship, but that's the date that you're writing the contract. Okay. Now, number 1 defines the agreement. And the important piece here is, you know, we have to define this agreement, and this is going to come into play when we get to section 7. So I want you to kind of hold this thought, but this piece is extremely important because what this does is it says the buyer and the brokerage firm are entering into this exclusive, meaning buyer is working exclusively with you. It doesn't mean that you're working exclusively with them, right? I can have other buyers who might be interested in seeing the same property. And we'll talk about that a little bit, but it's exclusive in regards to the buyer working with you as the broker, right? They are agreeing to work exclusively with you. It's an irrevocable contract. It can't just be revoked, right? One party can't just say, hey, I changed my mind. I don't want to work with you. No, you can certainly terminate it with mutual agreement between the parties, right? And if both parties agree in writing that you're going to terminate, that's okay. But one party just doesn't have the right to revoke this contract. It is not a unilateral contract. It's a bilateral contract. Okay. And the buyer and the brokerage firm agree to the provisions that are set forth herein, right? Buyer or broker on behalf of the brokerage firm agrees to provide brokerage services to the buyer. So that's probably the most important piece when we get down to section 7, is that you are agreeing to provide brokerage services. Okay, so hold that thought. Brokerage firm will receive compensation, but only as set forth in this buyer listing contract. Okay, so what section 7 does is it spells out what are the terms under which you will receive compensation as set forth in this contract. Okay, and remember that regardless of how you lay that out in section 7, you are agreeing to provide brokerage services to the buyer. Okay, so let's jump down to section 7 and then we'll come back to this stuff. Okay, and what section 7 says is in consideration of the services to be performed by you, the broker, i.e. in consideration of you providing brokerage services to the buyer, right? The brokerage firm will be paid as set forth in this section with no discount or allowance for any efforts made by the buyer or any other person. And so, you know, and you might have a buyer who says, hey, like I found this property on Zillow. You didn't even send it to me. I want a reduction in the commission or whatever. No, it doesn't matter. I'm going to provide brokerage services to you. Doesn't matter if you found the property yourself. Doesn't matter if you went and heard it from your neighbor and you decided to buy their property, right? I'm still representing you. You still have the obligation set forth herein. Okay. Unless otherwise agreed to in writing, brokerage firm is entitled to receive additional compensation, bonuses, and incentives paid by the listing brokerage firm or seller, and broker will inform the buyer of the fee to be paid by the brokerage firm. If there is a written agreement, buyer will supply a copy to the buyer. Okay, so if you lay out your success fee down here as 2.8%, and you go and show a property and it's 3%, well, you are entitled to receive that full 3% that's being offered. Okay. You're not obligated to kick it back to the buyer. Same thing, if your success fee was 3% and you're working with a builder who's got some incentive running and they're offering you 4%, right? You're authorized to accept that 4% commission with no obligation to kick it back to the buyer. Okay. So 7.1 talks about the brokerage firm's fee and purchase, which is defined up above. So we'll come back to that purchase, but you have to check what is the compensation arrangement going to be. Well, in most cases, we're going to have some form of success fee. We're not going to have an hourly fee. We're not typically going to have a retainer fee. We're not typically going to have some other form of compensation, right? It's just typically we're going to be paid a percentage of whatever the price is. Okay. And real quick, Kevin chats in here. He says, I have an exclusive right to buy. Oh, this is a direct message. Let me hold on. I'll screen it first before I read it to everybody. Okay. Yeah. So this could go to the group. So Kevin says, I have an exclusive right to buy with a 3% compensation, and it's under contract for a property stating 2.8% will be paid. Should I do an amend extended to 2.8? And the answer is you certainly don't need to, and you're not somehow obligated to go collect it from your buyer either. So hold that thought though. Let's come back to that because that's going to apply. That's a good question for when we get down to section 7.3. Okay. But the short answer to the question is no, you don't need to do an amend. Okay. So again, we're typically going to have some form of a success fee as opposed to hourly fee, retainer fee, or some other compensation. Okay. So if that's the case, we need to check this box, because if we don't check a box, right, what does it mean for that provision? It means that that provision doesn't apply. Well, we do want it to apply. So check the box, right? This is one of the biggest things that we see is people don't check this box, but then they come over here and they write 2.8 or 3% or whatever it is. Well, technically what you're saying is if you're not checking that box, it doesn't matter what you've written in here, your success fee doesn't apply and you're working for free. Okay. So if that ever got wrapped up in a lawsuit, the buyer goes to sue you and say, hey, you didn't, do your brokerage duties. And, a judge looks at this, they could say, well, technically you didn't check this box. Therefore that success fee doesn't apply regardless of what you happen to write in here. So even if you earned a 3% or 2.8 or 2.5 or whatever it was, even if you earned a commission on the deal, you have no right to keep it because this didn't apply. So go ahead and cough it up. Okay. Now that has nothing to do with who is obligated to pay your success fee. Okay. So we'll come back to that later, but people have this misconception that if they check this box, that the buyer is obligated to pay. That is 7.3. That is not 7.1. Okay. All we're saying is which arrangement are we going to go with as far as our compensation is concerned? Check that box if that's what you want. Now, it's theoretically possible for you to work on an hourly fee. It's theoretically possible for you to work on a retainer fee. And it's theoretically possible for you to have some other form of compensation. However, I highly recommend not doing any of those things because, you could run into RESPA issues if you're not versed in RESPA. You could just run into all sorts of weird stuff. Retainer fees are typically like attorneys work on retainer fees. So are you crossing that line from broker to attorney? Like, where are we drawing that line, right? The best thing you can do is probably just check this box and put whatever your success fee is going to be. Now, it doesn't have to be a percentage. You can come over here and put, hey, I'm not going to work for it on any deal unless I'm getting a success fee of at least $5,000 or 10,000 or whatever your number is, but typically it's just going to be a percentage. Okay. And you put that here, make sure you check that box in 7.1.1. Okay. Now, and in most cases, we're not going to have an adjusted amount. If you do have an adjusted amount, then you could check this box as well and say that just says see additional provisions. And that would talk about some form of adjusted compensation, right? You might have 3% on any properties up to 750,000, 2.8 on anything up to $1 million, and 2.5 up to 1.5 million, right? Whatever you want as far as an adjusted amount, you can do that. And you would probably have to put that in additional provisions, okay? Other, you could certainly check the other box if you have some other weird arrangement, right? But that's probably all just going to go in additional provisions, okay? 7.1.1.3 says the success fee, which we've effectively called we'll call it the commission, right? So our commission is earned, and there's a difference between earned and payable, and this is where it sets it out. So our success fee is earned by the brokerage firm upon the purchase with a capital P, which we'll come back to, purchase of the property, but it is payable upon the closing of the transaction. Now, if you've been in, my contracts classes, or you understand, writing contracts, what does it tell you that this purchase price, or that this purchase is capitalized with a P? What does that tell you about the term purchase?
It's a defined term in the contract.
Yeah, it's a defined term in the contract, right? And so we have to figure out, okay, what does purchase with a capital P actually mean, right? So we come back up here, and I know we're like hopping all over the place in this contract. I promise it'll make sense at the end, okay? So purchase is defined right here. A purchase with a capital P of the property with a capital P, which is defined here, right? A purchase of the property means the acquisition of any interest in the property or the creation of the right to acquire any interest in the property, including a contract or lease. So according to this form, when is a purchase considered done? I mean, not complete, but when is a purchase according to this contract?
The signing of a right to purchase. I mean, the signing of a deal.
Yep. So a contract to buy and sell, when it is fully signed by all parties, right? So what you and I would call going under contract. When you go under contract, you have just created the right to acquire an interest in the property. That makes sense to everybody? So if we go back and we read this, okay, that success fee is earned by the brokerage firm upon the purchase of the property. In other words, we have earned our commission once we have a fully executed contract to buy and sell between the buyer and the seller, right? Now, it's not going to be paid until closing. However, if the transaction fails to close as a result of the seller's default, where the buyer is not at fault, then that success fee will be waived. In other words, yeah, you did some work on the deal, the seller defaulted, but we can't stick the buyer with the commission because the seller defaulted, right? That doesn't work. However, if the transaction fails to close as a result of the buyer's default, in other words, buyer says, hey, yeah, we were under contract on 123 Main Street. And, I've just decided that I don't like that location anymore. Or, I want to pursue other properties. I think we made a quick judgment decision and we didn't really think it through, right? Then technically you have earned your commission, okay? And what it says is, if it fails to close as a result of the buyer's default in whole or in part, that success fee will not be waived, and it is payable upon the buyer's default, but not later than the contemplated closing date of the transaction. Okay, so buyer, you could say, okay, buyer, I understand that you don't want to purchase the property. However, you're in default. You're probably going to lose your earnest money, and that commission is payable, right, upon your default, not later than closing. So do you really want to default that bad, right? Where you're going to walk away from your earnest money and you're going to pay me the commission. Now, again, it doesn't obligate you to go pursue the buyer for the commission, but you have the right to do that. Okay.
How would you do that, Jesse? I mean,
Well, you're probably going to have to get attorneys involved because the buyer's probably not just going to be excited about coughing that up. And in many cases, right, the buyer may say, hey, yeah, I'm defaulting on this one because I found another one that I want to purchase better, right? And I still want you to represent me on that one. Well, if that's the case, I'm not going to go pursue them for a commission on this one and also pursue, you know, get paid double on the other one, right? So I'm not probably going to do that. However, you do have a right to do that, particularly if the buyer just says, yeah, I just changed my mind. I don't think I want to buy a house anymore. I'm worried about the economy, right? I think I'm just going to continue renting. Well, buyer, we're under contract on this property. I've earned a commission and it's payable upon your default or not later than closing, right? So we can either move forward with this deal, or if you just don't want to do it, I can then pursue you for the commission, right? You have a right to do that per our contract, assuming that box is checked. Okay. But yeah, in most cases, if it truly comes down to that second scenario, you're probably going to have to get attorneys involved because buyer probably is not going to be excited about just saying, oh, yeah, Jerry, here you go. Here's $12,000 for you, right? It just doesn't work that way. Okay. We're going to skip over.
How often, Jesse, though, have you ran into that? Like, have you ever done that? Because I just know me and my own personality. I'd be like,
Yeah.
man, that sounds like a lot of stress for a check. I don't know if I want to go through that stress for it.
Yeah, so I personally have never pursued a buyer under that clause in our contract. I have seen it done before, very seldom, right? It is not something that occurs very often. And, you know, it's not anything that has occurred, at least as far as I'm aware, under my, you know, under my tenure as the employing broker at my brokerage firms. But it is a real thing that certainly has happened where brokers have, you know, dumped a ton of money into marketing, you know, and a lot of times it happens more on the seller side than the buyer side. Where sellers are like, okay, yep, you know, we want to sell, we signed a contract, you spent money on, you know, marketing and all this other crap. And then lo and behold, the sellers are like, hey, you know what? Like, there's just nothing else out there that we like better. We're just going to stay, you know, and they've already accepted a contract on the property. The commission's been earned, right? Sellers have defaulted. Well, I've earned my commission as the listing broker at that point. And so that's the situation that I've actually seen a real deal where that has happened before. But yeah, I'm the same. Like in most cases, I'm just not going to pursue a buyer under that particular provision in the contract. Okay. So going to skip over hourly fee, retainer fee, other compensation, lease fee, all that other stuff. Okay. Because I don't really advise that you guys do any of that stuff. It just gets, it gets hairy from a legal perspective. Okay. All right. So 7.3 is where it talks about who will actually pay that brokerage firm success fee. Okay. And so we have a couple of different options here. And usually we either see 7.3.1 or 7.3.3. 7.3.2 is an option as well. But what's 7.3. Let's go to 7.3.3 first. Okay. And honestly, I would say that this is what I see like most of the time, but just barely most of the time, like maybe 50%, 55% of the time, you know, 55, 60% of the time, this is what we see. And what this says, you know, if this box is checked, the listing brokerage firm or seller may pay, but that buyer is not obligated to pay your success fee. Okay. And so if we read the verbiage here, what it says is you are authorized to obtain payment of your brokerage firm success fee from the listing brokerage firm or seller. However, if the buyer has fulfilled their obligations in the buyer listing contract, buyer is not obligated to pay your success fee. Okay. And then there's the caveat here. If you haven't checked any of these boxes above, then 7.3.3 will apply. In other words, the buyer's not obligated to pay your commission. Okay. So I want you to look at that first little bit the broker is authorized to obtain the payment of the success fee from the listing brokerage firm or seller. And now I want you to compare that with 7.3.1 and tell me what's different between the two. What's the difference between the verbiage in 7.3.3 and 7.3.1?
The brokerage does one.
In 7.3.3, is that what you're?
Yeah, that's what I'm thinking.
So just look directly at the words. It's in the first like 5 words of the first part of 7.3.1. There's a word in there that is not in 7.3.3, and it says you're not only authorized, but you are instructed to go request payment of your success fee from the listing brokerage firm or seller. Okay. What 7.3.3 doesn't say is that you are instructed to go request payment from somebody else. And the reason for that is if the buyer is not obligated to pay your commission, you have no right to go ask the listing brokerage firm or seller to pay your commission, because that would be putting your buyer at a disadvantage, right? By asking for more commission in the deal. If your buyer's not obligated to pay, then they don't have to pay, and you're just going to take whatever is offered. And guess what? If 0% is offered because it's a FSBO who doesn't want to pay, and you've checked this box that says 7.3.3, buyer's not obligated to pay. If we think back to section 1, the agreement, right? What did the agreement say that we were agreeing to do on behalf of the buyer? You guys remember? What was our agreement? What were we going to do for the buyer?
Provide brokerage services to buyer.
Yep. We are agreeing to provide brokerage services to the buyer. And then so if we come down here and we check 7.3.3, right? Then we've agreed to perform those brokerage services to the buyer. And if the buyer's not obligated to pay, it doesn't matter. We still have to provide brokerage services, even if the seller does not offer any compensation or co-op commission. So how many of you got into real estate because you wanted to work for free and just do this as a charity? Nobody? So if that wasn't your goal, was to do this for charity, then why are you checking this box? Okay. You are offered, zero protection by checking this box, and you are obligating yourself to provide brokerage services. Okay. So if you want that protection, then come up here and check 7.3.1 that says you're not only authorized to collect whatever they're offering, you are also instructed to go request payment of your success fee from the listing brokerage firm or the seller. If you check that box, you have a right to go ask for more commission up to whatever your success fee is. So if you go, if you've signed this and you check the box that says 7.3.1, and in the success fee, you put 3%, okay? And buyer goes to see a listing that's offered at 2% co-op commission, you have a right to go ask for an additional 1% in the contract to buy and sell if you have that box checked. If you have this box checked, you are not instructed to go request payment of your success fee from the listing brokerage firm or seller. You are authorized to obtain the 2% that's being offered. Okay? Does everybody understand the difference between the two?
Is that a detriment though? I mean, as far as if the seller already has their agreement of what they're gonna pay the broker, and you come and say, no, I want you to pay me this much. Is that a detriment to your own business?
Well, so let's talk about a couple scenarios, right? If you're in a multiple offer situation and you're going to ask for an additional 1%, right? does that hurt your buyer's bottom line, or really the seller's bottom line, and hurt your buyer's chances of getting that commission or getting that offer accepted? The answer is yes. However, they've agreed that you have the ability to do that, right? Now, if we're talking about a property that's been on the market for 2 months and whatever, right? Does it really hurt anything for you to be able to go ask for your success fee from the listing brokerage firm or seller? Probably not. If they ever want to get the property sold, they're going to have to do something, drop the price or whatever. Okay. And really the other thing that is important here is, even though the buyer is obligated to pay, it doesn't mean that you're obligated to pursue them, right? And so it's feasible that, the buyer looks at this and go, whoa, I really don't want to be obligated to pay your commission. Okay, well, that's okay. I understand that. And I'm, really the important thing here is that this allows me, by checking this box, this allows me to go request my payment for the brokerage firm success fee, right? And just have the discussion with them, right? If you find a for sale by owner that's not offering any commission, right? I've agreed to provide you with brokerage services, okay? And I would really like to be compensated for providing those brokerage services to you. I'm offering up my time, my talents, my knowledge, right? I'm protecting you. I'm taking on liability. I don't do that for free. So I just need to know that you're going to allow me to go request payment of my success fee from the listing firm or, listing brokerage firm or the seller. Whereas I have no legal right to do that down here. And I don't want to represent you for free. I don't care how much I like you. I'm not willing to take on thousands of dollars of liability for you to get a house with nothing to show for it in return, right? This is how I feed my family. I don't ask you to do your job for free for me, right? So usually if you have that conversation with them, they go, okay, yeah, I understand. That's okay. And, if they say, well, that's okay. Like, I don't want to be on the hook for 3%. Well, you can negotiate lower than 3%, right? You can come up here and put in your success fee, 2%, right? And then if they're offering less than 2%, you can ask for 2% and pursue the buyer for anything up to 2%, right? And then if they say, well, yeah, hey, since we tried to negotiate with the seller and the seller wasn't willing to pay that 2%, like, I don't want to come out of pocket, so I'll just pursue another property. Okay, that's fine. That's their decision at that point. And it's not my decision to not show them a property based on the co-op commission, because you can't do that. You cannot refuse to show them property just because the co-op commission is lower than what you had agreed to, right? Particularly if you had checked that box in 7.3.3, said buyer's not obligated to pay. Well, if they want to go see it, guess what? Showing property is part of your brokerage services. You got to go show it to them.
Does that include FSBOs?
Correct. You still got to go show them FSBOs. Doesn't matter. Okay, because that's part of your brokerage services, is showing property. So if you don't want to work for free, if you don't want to be a charity, then go check the box in 7.3.1, right? Have a candid conversation with the buyer that, hey, this doesn't obligate me to go, sue you for the remainder of the commission. However, I have a right to go ask for it. And if you want to pursue a for sale by owner or someone else who's offering a $1 co-op commission, right? Then yeah, I do have the ability to pursue you for it. Or you can make the decision that you don't want to pursue that property, or maybe we can negotiate a discount on the purchase price, right? So that way, then theoretically there may be some money in the deal for me. Okay. Does that make sense to everybody?
Makes sense. So one other piece of that. So again, you have the conversation with your buyer. If you are in a multiple offer situation, though, how do you can you handle that negotiating with the seller too, putting in as like, hey, I'm instructed to request this, but you can stick with what your original is? Does that make sense?
You don't have to ask for anything extra, right? And so
So you don't
Right.
have to say anything about it. You just can if you want to.
correct.
Okay.
Yep. And you have the ability to pursue the buyer for the difference. So if you say, hey, buyer, like they're only offering 1% and we have 2.5 as our success fee, right? They're offering 1%, we're at 2.5, right? I don't want to hurt your chances of getting your foot in the door. So I'm not going to ask for the extra commission, but you're going to be on the hook for 1.5%, or I'm going to pursue you for at least half of the difference, right? Like it's up to you. You have a legal right to do it. You don't have an obligation to do it. So it's just protecting you in the sense that you have a right to go seek additional compensation up to and not to exceed your success fee, so that you don't get stuck doing brokerage services for free. Does that make sense?
Yeah, that does. Thank you.
Any other questions on those two? So 7.3.2 is the, another potential option where it just says the buyer will pay. And that's not typically one that you're going to see checked very often. Every now and then you might have, real example for you. Some of my clients that I've done, 9 or 10 deals with, they came to me one day and they said, hey, we know of these people that are selling the property. They want this price. They're not willing to pay any commission out of that price. So we would like you to represent us in the deal. The seller will be a customer, and we'll just pay your commission, right? So I have done that before where I've checked 7.3.2, but it's just not very often that you're going to run across that scenario. But what that says is that the buyer is obligated to pay your success fee. You're not entitled to receive any additional compensation or bonuses or incentives from the listing brokerage firm, the seller, or any other source, right? Because if the buyer is obligated to pay, then I can't ask the buyer to pay plus take extra from the seller, right? That kind of defeats the purpose of having the buyer pay as opposed to checking one of these other two boxes. Okay. Let's talk about holdover period while we're here, and then we'll jump back up. So what the holdover period, this is one of the, again, like most misunderstood clauses in these contracts, okay? And what it says is that the brokerage firm's success fee or the commission applies to property that is contracted for, not closed, property that is contracted for during the listing period, okay? And the listing period is defined up above. We just haven't got there yet. Of this buyer listing contract or any extensions. And it also applies to property that is contracted for or leased within X number of calendar days after the listing period expires. Okay. So I always get the question, what should you put in here? There's no right or wrong. Okay. I would probably say it shouldn't be more than 365 days. And probably the most common thing that we see is like 30 days. But you could do 7 days, you could do 1 day, you could do 180 days. There's no real right or wrong other than I wouldn't go longer than 365 days. Okay. So, however, there's some caveats to that. Okay. So the holdover period applies for property that is contracted, during the listing period or after the listing period expires, if the property is one on which the broker negotiated. Okay, now that doesn't mean that you had to have written a contract on the property. It's entirely possible that, you submitted some feedback and you said, hey, the house would really work well for the buyers. However, they don't like the fact that the carpet's all worn out. The yard's a little smaller than they were hoping for, right? And now you've opened up some dialogue. And the listing broker says, hey, totally understand, man. We'd love to see an offer from you. Let's see what we can put together, right? So, okay, now you've kind of got some dialogue going. Are you starting to negotiate even though you haven't submitted a formal written offer on the contract to buy and sell? Yeah, you are, right? That's certainly considered negotiating. Okay, so the holdover period applies if it's a property on which you negotiated. So it doesn't apply to one on which you have not negotiated. So in other words, if your holdover period is 30 days, right? And they go and they contract for a property that you've never seen, it's new to the market, you haven't negotiated on it, and they contract for that property with a different broker within 7 days, and your holdover period was 30, you don't get a commission on that deal because you never negotiate on that property. Okay. So for one, it has to be a property in which you've negotiated, and not or, and. So this also has to apply. You have to, as the broker, submit the address or other description in writing to the buyer during the listing period. You cannot wait until the listing period expires and then give them a list of, you know, all the properties that you showed them that you've negotiated on, right? You have to do it during the listing period. So the holdover clause only applies if it's one on which you've negotiated and you've submitted that address to the buyer during the listing period, not after. Okay. And then there's one final caveat here, and it says, however, either the buyer will or will not owe that success fee if a commission is earned by another brokerage firm acting pursuant to an exclusive agreement with the buyer that was entered into during the holdover period and purchase or release of the property is consummated. Okay. And so effectively all that means is, if the commission is earned by another brokerage firm, is the buyer going to be obligated, or are they not going to be obligated to pay you a success fee as well? And, you know, the question we always get is, well, why would you ever check the will not box, right? The whole purpose is to, you know, protect you as the broker. Well, not necessarily, right? If we think about really why a holdover period was created, it was created to prevent a situation where, let's say the property's been on the market for 5 months and 29 days, okay? And the listing broker has a 6-month listing contract with the seller, right? So they have 1 more day to go on this thing, and you submit an offer to them, and the seller looks at that, and the seller's wise, and they say, hey, this is a little bit lower than what we were hoping for, but I know that my contract with the listing broker expires tomorrow. And so what I'm going to do is I'm going to reject this offer today. And then, you know, 2-3 days from now, I will go back to the buyer's broker and say, hey, now that my listing broker is out of the picture, that price that you offered on the home, if that's what it takes to get it done, I'm willing to do that because I don't have to pay a commission to the listing broker. I can save 3% or 2.8 or 4% or whatever it is, right? I can now save that commission, and therefore we can put this deal together. So in that case, what the seller is trying to do is cut an agent's commission out of the deal. Well, if a commission is earned by another brokerage firm, it's not that they were trying to cut a commission out of the deal, right? It's just that you didn't get the job done and they're giving somebody else the opportunity. Does that make sense to everybody? Anybody have any questions on that piece? I usually get more questions than this. You guys like, I put you to sleep already, or I just did that awesome of a job explaining it to you guys? Okay. If you guys have questions, let me know. So let's come back up to the top now. So define terms, right? The buyer, make sure that you've got anybody who's going to be on the contract. Multiple buyers, put multiple names in there. If it's just one, just put one name on there. Brokerage firm, whatever brokerage firm you work at. Broker, this is you. This is not me, the employing broker, your employing broker. This is you, right? Property means any real estate which substantially meets the following requirements or is acceptable to buyer. What I love seeing in here is when people put any property that's acceptable to the buyer. Well, this section is asking you what is acceptable to the buyer. So putting any property that's acceptable to the buyer in there probably doesn't work. Okay. So, you could put, you could put any real property in this section 3.4 as well. And that would, any real property in the state of Colorado, right, is generally what I put in there. And then that way, if they purchase any real property, then it applies. Now we have an interesting twist with manufactured homes, right? What happens if they purchase a manufactured home that's not on any real property? It's, you know, it's in a mobile home park. Then does your commission apply? I don't know. I mean, I could make the argument that it doesn't. And what we might see is when the exclusive right to buy gets revised, we might see this change to say property or home, because that's the term that's, I think that's the term that's used in the manufactured homes contract that rolled out this year, right? And for the time being, we don't have an exclusive right to buy specifically for the manufactured homes. We are still just using this exclusive right to buy, which has this term property, which may not apply to manufactured homes. So if that's the case, you may need to put in here any real property in the state of Colorado, or any manufactured mobile modular homes that, you know, are titled homes, or however you want to define it. Just make sure that it's clear that it also applies to manufactured homes. Okay. A purchase or lease, we already talked about purchase. It's defined at what it's defined as. It also includes an agreement to acquire an ownership interest in an entity that owns the property. And the reason that they put this in here is because there were some people who thought they were smart by transferring the property into an LLC in order to avoid paying a commission, because that LLC was not defined as, you know, the buyer, or, you know, I think it was actually on the seller side, but now it applies to both, right? So that's why that's in here, is to avoid someone from flipping the name into an LLC and then saying, oh, I'm not obligated to pay a commission because the legally defined buyer is not who's on contract to the property. Okay. We're not typically going to check the box in 3.5.2. That's to negotiate a lease of the property. Okay. 3.6 defines that listing period. So again, we have the date of the contract, and this is the date that you're writing this contract. And then we have the listing period. Now, in most cases, it just makes sense to start the listing period.
For dine-in?
Oh, Gary.
Okay, very good. Thank you.
See if I can mute Gary.
Bye.
There we go. So the listing period it generally just makes sense to start it on the same day that you actually write the contract. Maybe not so on the exclusive right to sell, but on the exclusive right to buy, there's really no reason, in my opinion, to have this start on any day other than the day that you're writing and signing the contract. Okay. And then it will continue through the earlier of the completion of the purchase of the property or lease of the property or whatever ending date. Okay. Again, question is, you know, what do you typically put in here? What's acceptable here? And again, you could literally have a 1-day exclusive right to buy, right? If someone says, hey, Michelle, I'd really love to work with you on this particular transaction. However, I don't want to be obligated to work with you on any other properties, but I do want you to be my buyer's agent on this deal, right? And you say, okay, great. Are we writing the offer today? Yep, we're writing the offer today. Okay, if we're writing the offer today and it gets accepted today, then we've met that purchase, right? The capital P, the defined purchase of the property, okay? And so we could literally say, hey, it begins today and it ends today. Now, be careful because you don't know how long it's going to take the seller to sign it, right? So maybe you do like 3 days or 5 days or whatever. But what that does is it allows you to represent them as a buyer's agent for the purchase of this property, right? For a very short period of time. And you will actually continue to assist them through the completion of the property, right? Even though that maybe has expired. Does that make sense to everybody? The other potential option is you could make this contract specific to that individual property right here, or in additional provisions. You could just say, buyer and broker agree that, this agreement is only in relation to 123 Main Street, Anytown, Colorado, whatever. Okay. So there's multiple things that you could do here. So Michelle chimed in and she said, on this section, I've put down the closing date. So that's all fine and good, but the problem is, where is the closing date defined in this contract?
It's not.
Yeah, it's not. And so there's actually a real estate commission rule. This is a rule, not a commission position statement. The rule says we can't have an open-ended agreement whereby there is no end date. Okay. So in regards to closing date, the only thing to be careful of there is, what happens if they don't end up purchasing a property? Are they then still obligated to work with you into perpetuity, which is what it looks like in the contract, right? Because closing date isn't defined in this contract, that's defined in a contract to buy and sell. So I typically like to put it as a hard date. You could put it as an MEC date, right? There's some other potential option, but what the other thing that this contract says is that it will continue to assist, you will continue to assist in the completion of the purchase for which the compensation is payable, right? So you're going to do it through closing, and regardless of what that is, it's going to start on this date, whatever you put here, and continue through the earlier of the completion of the purchase of the property anyway. So it's already effectively defining what you're saying there, Michelle, is that it's going to terminate at the closing date anyway. Okay. So it's automatically going to terminate at the closing date. It's not defined as the closing date, but we still need to have an end date in case there is no completion of the purchase of a property, right? We have to have an end date per the real estate commission. So good idea to put a hard date in there. You could do an MEC date in there, but we can't have an open-ended exclusive right to buy or an exclusive right to sell where we try to lock them into, a contract into perpetuity. We can't do that. Okay. The other thing, and I argue with Damien on this, Damien says there's no limit to how long this can be. And I will tell you, there is a spot in licensed law where it says that no exclusive agreement can be longer than 1 year. Okay. So that's why I say 365. Damien doesn't think that applies for whatever reason, and I'm right and he's wrong. So don't make him for longer than 365. Okay. I think you're setting yourself up for failure. I'll go to battle with Damien on that one. And I've asked him specifically about it and he refuses to acknowledge it. So anyway, don't make it for longer than 365. That's my advice. Damien will tell you otherwise. So, okay. Let's see. So any questions on the listing period itself?
Yeah, Jesse, I just have a real quick question. So what if you do put an MEC date, let's just say plus 45, okay? And because this market is so crazy and trying to get buyers under contract is taking longer than anticipated.
Yep.
What if that does exceed 365? I mean, technically you have an end date in there of an executed contract plus 45 days.
Correct. So at the end of 45 days, if you haven't found them a property, you are no longer, this contract no longer applies.
Oh, I was thinking MEC of an actual executed contract to buy, sell that they're under contract. Never mind.
No. Yeah. So I get where you're going. Keep in mind, MEC, right, is defined here as mutual execution of this contract, the date by which both parties have signed this buyer listing contract, the parties being you and the buyer.
Yeah, got it. I'm brain jumbled.
Totally okay. Any other questions on the listing period? Okay. Applicability terms. So if we put NA or deleted, it means not applicable. If a check or a similar mark in a box, then it means that provision is applicable. And vice versa is also true. If a checkbox is not checked, then it's not applicable. And that's why it's important in 7.1.1 to check the box for success fee if you're hoping to get paid a success fee, right? Because if it's not checked, then it is not applicable. And if you put NA or delete it, then it means it's not applicable as well. MEC is a mutual execution of this contract between you, the broker, and the buyer, right? And then day is defined as ending at 11:59 p.m., just like it is in all of our other contracts. Now, again, keep in mind, you can change that, right? If you go into additional provisions, there's probably no reason to change it in an exclusive right to buy. But from time to time in a contract to buy and sell, you will see brokers and sellers or buyers and whatever who want to say that no, a day is going to end at 5:00 p.m. because I don't work after 5:00, or 8 p.m. because I don't work after 8, or whatever. So it is possible to change that. Probably no reason to do that in this contract. Okay. Computation of periods, days, deadline. So if you're computing a day when the ending date is not a hard date, right? Like if you were to say MEC plus 45, well, you don't have a hard date. So you have to figure out, okay, what is MEC plus 45? And does day 45 fall on a weekend or a federal or Colorado state holiday? And if it does, is it going to be extended or is it not? You know, generally speaking, I just write my contracts with hard dates. I don't use MEC in this contract for anything. I'll just do a hard date in here. Pick a hard date that's not on a weekend, and hopefully it's not a holiday, just in case in this contract, which is I don't do in the contract buy and sell, but in this contract, I typically check the box that says, you know, if that ending date happens to be on a holiday, then yeah, it's going to extend to the following business day. Okay. But check whichever box you want. If neither box is checked, then that deadline will not be extended. Okay. Okay, brokerage relationship. So if that buyer agency box at the very top of our contract is checked, then you are going to represent the buyer as the buyer's limited agent, or what we call the buyer's agent. If the transaction brokerage box is checked, then you're going to act as a transaction broker. You're going to treat the buyer as a transaction broker. Okay. And then we get into the what if scenarios, right? What if there's an in-company transaction where it's two different brokers? And real quick, I'll tell you there's a caveat for teams, okay, that's not listed in here, but the real estate commission considers teams to be one individual. Whether the team actually operates that way or not, right? So do we have anyone who's in here that's on a team? Okay, so Charlton and Naomi, for instance, husband and wife team. So in a specific transaction, right, Charlton may be representing the seller as a seller's agent, and because Naomi is on his team, she is assumed to also be a seller's agent for the seller. Therefore, we can't have Charlton be a seller's agent for the seller and Naomi be a buyer's agent for the buyer, because Naomi is already assumed to be a seller's agent for the seller, and we can't have agency and agency, right? If I'm the only broker in the deal, I can't be a buyer's agent and a seller's agent at the same time. So either they both move into transaction brokerage for the seller and they both become a transaction broker for the buyer, right? Or they both remain a seller's agent for the seller and treat the buyer as a customer. It's also theoretically possible, though not probable, that they say, hey, seller, we're going to ditch you because we like the buyer better, and we're going to treat the buyer as a buyer's agent, and we're both going to treat you as a customer. Okay. Theoretically possible, not probable. Okay. So keep that in mind when we're talking about this, regardless of whether your team actually operates that way. And maybe using Charlton and Naomi was not a great example because they're husband and wife, and that's probably how they run their team is truly that if Charlton has a relationship with one, Naomi has the same relationship, right? But think about maybe more of like unrelated team members where you have the team lead, and a lot of times they're going to be on the listing side, they will be the listing broker. And then if one of their buyers finds an unrepresented buyer, they go, okay, well, the team lead is a seller's agent for the seller. I'll be a buyer's agent for the buyer. can't do it. Because you, as the buyer's agent for the team, right? Your buyer's agent for that team lead, you have that same brokerage relationship that the team lead has with their client. Okay. Anybody have questions about that real quick before we move on? Okay. So in-company transaction with different brokers, again, forget about the team thing, right? We're talking about different brokers, different teams, okay? If that were to come into play. So different brokers. So when the seller and buyer in a transaction are working with different brokers within the same brokerage firm, then those brokers continue to conduct themselves consistent with whatever brokerage relationship they had already established with their client. So if Brandy is representing a buyer as a buyer's agent and Charlton and Naomi are representing the seller as the seller's agent, even though they're at the same company, right? Even though they're both at the Loveland office, Brandy can be a buyer's agent for the buyer. Charlton and Naomi can be a seller's agent for the seller. And there's no conflict of interest there because there is no imputed knowledge that, you know, Charlton and Naomi have of Brandy's clients and vice versa. Okay. Buyer acknowledges the brokerage firm is allowed to offer and pay compensation to brokers within the same brokerage firm working with seller. Okay. But then what do you do when you have an in-company transaction with one broker, or an in-company transaction within a team would also apply because a team is assumed to be one broker. Okay. So if the seller and buyer are both working with the same broker or the same team within the brokerage firm, then the broker will function as follows, right? If you're a buyer's agent, if that box is checked at the top of page 1, parties agree that the following applies. And so now you have an option, right? Default is that you're going to be a buyer's agent unless you have a brokerage relationship with both, in which case, if you have a relationship with both, you would be able to flip into a transaction broker, okay? The other option, if this is checked, is that you would remain a buyer's agent only. So if you happen to come across a seller who says, hey, I'm looking to sell, you could not flip. If this box is checked, effectively what you're saying is, I'm going to remain a buyer's agent for the buyer, and I'll have to treat that seller as a customer, or I'd have to refer that seller out to someone else if the seller requires some form of brokerage relationship. Okay. Does that make sense? Okay, transaction broker. If, you know, again, we're talking about an in-company transaction with one broker, or, you know, within a team, right? If the team is already functioning as a transaction broker, then, or if neither box is checked at the top by default, you're a transaction broker as opposed to an agent, right? Then the broker must work with buyers as a transaction broker as well. Okay. So then we get into brokerage duties, but, you know, and it tells you, you can't, you have to perform the duties described in section 5 and facilitate the transaction without being an agent or an advocate for either party. Okay. So then we get into section 5 duties, and this is going to take too long. So we're going to end it a little bit early today. We'll stop it there. And then next week we'll pick up with the brokerage duties of a transaction broker. But you guys have any questions from today? Anything that's come up? Any weird stuff?
This, Jesse, can you hear me okay?
Yep.
This might have been a good question to bring up during the holdover clause, because I don't think we can have a discussion of a right to a disclosure to represent, or an exclusive right to represent, without discussing procuring cause. I just wonder what your thoughts are on that briefly. I know it's a topic you can dive pretty deep into, but.
So what specifically questions do you have on procuring cause?
Well, I guess, yeah, every situation has to be handled differently. But just as it pertains to the holdover period, I mean, that's one issue where procuring cause does come into play a bit. So.
Yeah, so a couple things. I mean, one is if you have given your client, the buyer, right, a list of properties on which you have negotiated, and you've given them that list prior to the termination of this contract, right, not termination, prior to the expiration of this exclusive right to buy, then you're effectively covered under that holdover clause, regardless of whether anyone happens to be the procuring cause or not. The other broker may try to claim procuring cause, and in that case, it is up to the buyer to, you know, have that battle with the seller because they're already obligated to pay you, right? And procuring cause, a lot of people have misconceptions about what procuring cause is, right? But procuring cause is a series of events that lead to a successful closing of a transaction. Now, it doesn't mean that you show them a house. That's not procuring cause, right? Procuring cause does not mean that you have to be present for every step associated with that transaction. It's a series of events that leads to the successful closing of the transaction. And like you said, it's going to differ in every situation as to, okay, who was the actual procuring cause? And in many cases, what ends up happening regardless is that it gets negotiated to be something more than 100, you know, something other than 100% to this party or 100% to this party, right? In many cases, it's like 75-25 or 50-50 or 60-40, right? So at the end of the day, procuring cause typically involves some negotiation, but between you and the buyer is obligated to pay your commission if the terms of the holdover clause, you know, are met, regardless of whether someone else claims to be the procuring cause, right? Now, you may have to prove that, yes, this is in fact a property on which I've negotiated. And how can you do that if all of your conversations were via phone, right? I can't tell if you've negotiated on a property if all of your negotiations were via phone. Now, if you've filled out feedback and you've sent the listing broker some emails and, you know, that you've back and forth with them, right? You're trying to lock down a deal and it just never materialized. Well, that's negotiation, right? And that's written so you can prove it. Certainly if you wrote an offer and it just never got accepted, that's easy to prove. And as long as you gave them, right, then that property address before the termination or before the expiration of this contract, then the holdover clause applies. Now, we still have that one other caveat. Is it going to be earned if the commission is earned by another brokerage firm? If you've checked the box that says yes, then if they claim to be procuring cause, that's okay. Your client is still obligated to pay you, right?
Mm-hmm. Yeah.
And if you've checked the no box, then they claim procuring cause, right? And they've earned a commission. Even if you think you were procuring cause, if they earned the commission on the deal, you're not obligated to, or you are not entitled to receive any additional compensation via the holdover clause because you checked the box that said you will not.
Okay.
That makes sense?
Yeah, it sure does. I appreciate that.
Okay. Other questions? Okay. That's all I got for you guys. We'll pick it up in section 5. You guys will probably have to remind me because I'll forget by then. So if you're taking notes, let us know. But that's all I got for you this week.
Thank you, Jesse.
You bet. We'll see you guys.